Well, Your Honor, there is a bit of a concern. The resolution of this issue is holding up the development of the property, and though we wouldn't insist that a ruling be issued today, we would ask that a ruling be issued as soon as reasonably practical based on the evidence that's submitted. So if it could be within, 2 weeks or sooner, as practical, that's what we would hope for. Okay. Okay. Thank you. No objection. No, no objection from appellant. Well, none from the appellant's perspective that you've forgotten to include. I do have an additional 3 exhibits I'm hoping to submit. I've got working copies and a copy for Your Honor. It's not one exhibit that I would refer to as, C1, C2, and C3. I would refer to it as C3, is a brief memorandum referring to another development by the name of Glenbrook that the city has, from 2014, that the city has had some interaction on. So that's just a memorandum referring to that. And then the other 2 exhibits are various financial, tree unit and numeric calculations based on the city's code. I would suggest these are not new information than the exhibits we submitted, but they're rather various examples of calculation under the city code. So I can offer at the time of presentation. They were exhibits prepared to help explain the materials that we have submitted. So they're not new information, but they're explanatory of what we've already submitted, both in exhibits and in argument with our briefing. I'm offering them like trial exhibits. Your Honor, I haven't provided them. So I should do that. For the sake of marking and the discussion, do you have a?
So this is a memo that we provided you?
No, it's a memo that I've prepared. Yeah.
allow these? We would like to have some time to review these afterward, or, yeah, a written response.
Your Honor, can I make one additional comment in support of offering these exhibits? It is my understanding that the code expressly authorized the additional submission of exhibits at the hearing. I have the code here, but I can't find the site. I'd be happy to provide the city immediately following the closing of the hearing today, that site, so it would aid in their response. Yeah. Okay. Well, good afternoon. For the sake of the record, my name is Matt Cruz. I'm an attorney in Edmonds. I am appearing on behalf of Bellmark Homes and Aaron Metcalf, the appellant in this matter. Your Honor, we're here today to do really three things. First, we concede the trees were removed. The trees at issue in this matter were removed without the benefit of an authorizing permit. I stop and make that point because we do understand that this is a mitigation hearing, not a contested hearing. I would not want any of my remarks to be mistaken as issues to contest liability. Secondly, we're here, Your Honor, to respectfully assert that we believe the factual record should be corrected in a few important areas. It appears to us that there may be some misunderstanding, and I'm sorry, I should stop and say preliminarily, we're here today pointing out misunderstandings or differences of views concerning the factual record without ascribing any intent on behalf of the city or ill will on behalf of the city. We just believe that we view the factual record a little differently, and I'd like an opportunity to walk through that, explain the basis for how we view the factual record differently, because we think that's important as we proceed to the third area that we want to cover, which is presenting our mitigating factors. Okay? I think the first issue that we'd like to address, based in part of our review of the city's response in these proceedings, is this whole issue about whether the trees were removed after the city told Bellmark not to remove the trees. Setting aside for the moment whether the trees could be removed or should have been removed, again, we concede there was no permit issued, so there was no authority to remove the trees. But for the moment, setting those issues aside, we want to clarify that Bellmark and Mr. Metcalf did not remove the trees after he was told not to. We've submitted materials, Your Honor, that establishes, I think, the following sequence of events. It appears to us, if you look at our exhibit list, exhibit number 3, there's a city comment document that's dated November the 16th, 2016. Yes, Your Honor, I do.
Their exhibits or my exhibits? Their exhibits.
So I was referring to Exhibit 3 to our materials. This is a document on City of Kenmore letterhead, development and review comments dated November 16th, 2016. I don't think it's disputed, for the sake of context, that the trees were actually cut down. There were 5 trees cut down on the subject property on November the 17th, the day after the date of these comments. What I'm here to point out is these comments weren't in fact received by Bellmark or Mr. Metcalf until November the 21st. On November the 21st, he received them in 2 ways. In the morning on November the 21st, he received an email from the city with these comments attached. He wasn't able to open the attachment, so what he did was he contacted the city right away and arranged to pick up a hard copy of these comments the same day. And he, in fact, did. Excuse me, Your Honor. Oh. I'm sorry, Your Honor. Slight correction there. The attachment to the email he received in the morning of the 21st, he was able to open and view them. He did not view them. He was not able to print them due to problems at his office. He just couldn't print the document. But the same day, he went and arranged to pick up a hard copy from the city, and that, in fact, happened. I had intended this to be an opening statement. If, for the sake of the record, actual testimony is required, certainly we're prepared to offer the testimony in that form. I think we should just Sure. Sure. Okay. Okay. Sure. Your Honor. So the record will reflect then that he received first notice of these comments on the 21st. The record will also reflect then that he, I believe there's no dispute that the trees were cut down 4 days prior on the 17th. And so the point is, there may be some mistake as to whether, as the city is asserting, the removal of the trees was done after Bellmark or Mr. Metcalf had already received notice that we've referred to here as our Exhibit 3 not to do so. We believe the record will reflect the cutting occurred, though admittedly without the benefit of a permit, but before he actually received notice not to remove the trees. The next event that the record will reflect, relevant event, is a notice of violation was issued on December the 5th, 2016. And the record will reflect that when Mr. Metcalf and Bellmark received that notice of violation, he immediately sent an email to the city, the record being reflected in Exhibit 6 to our materials. He sent an email to the city, number one, admitting that he cut the trees on the 17th. The email indicates acknowledging he assumed a permit would be issued. It indicates also that he immediately apologizes. That's 3 o'clock the same day that he received the notice of violation. Now, the record will also reflect that when the original permit application was submitted by Bellmark for building or developing the property, included with it a tree protection and replacement plan, and that plan met the true and correct density standard imposed by the then existing Kenmore Municipal Code. That standard being 4.4 rather than the 9.6 tree units presently being imposed by the city's review. In addition to the original tree protection and replacement plan submitted by Bellmark for this property, which incidentally is just 6,270 square feet, as indicated on the original short plat creating the lot. And on that short plat, the subject parcel is referred to as Lot 1. The already improved parcel is referred to as Lot 2. When the original tree protection and replacement plan was submitted by Bellmark, it submitted on the basis that Lot 1 consisted of slightly more square footage than is reflected on the short plat. The slightly higher figure is 6,362 square feet as opposed to 6,270 square feet. The net effect of the resulting tree unit calculation is this. At 6,270 square feet, the tree density calculation is 4.3 units. At the higher 6,362 square feet, we believe mistaken area, the tree density unit calculation is 4.4. Yes. For purposes of this hearing, Bellmark asserts the correct standard will be the 4.4 units, the higher level, assuming the higher area of Lot 1. Yes. Now, the record will reflect there's an additional disagreement over the nature and number of trees that the city would have authorized. The record will reflect that initially the city had imposed a penalty of $235,800 based on the removal of all 5 existing trees on the lot. The city later amended that penalty down to $88,600 on the recognition that the city would have allowed Bellmark to retain 2 of the 5 trees it removed pursuant to its application for permit. You'll hear, however, that there's a little bit of a disagreement or misunderstanding as to which of the 2 trees the city would have allowed to remain. And I'll refer you to Exhibit 8 to the appellant's materials. At the appropriate time, we'll be going through that exhibit and demonstrating that the appellant asserts it would not have kept trees number 1 and number 2 on that exhibit. It concedes it wants to keep tree number 1, but the issue has developed between tree number 2 and number 5. As Exhibit 8 reflects, tree number 2 is within the proposed building footprint, whereas tree number 5 is similarly situated toward the bottom of the exhibit there, near the road. It would be trees number 1 and 5 that appellant would have wanted to keep, not trees number 1 and 2. And that makes an important difference, as we'll present, as we think the evidence will support, because that makes us about a $22,000 difference in the beginning figure from which we're seeking mitigation. According to the city's view, had we kept trees number 1 and 2, the beginning mitigation penalty, or penalty from which we're seeking mitigation, is $88,600, based on the removal of trees 3 through 5. However, the appellant asserts, in fact, they would have requested to keep trees number 1 and number 5. And because of the difference in size between tree 2 and 5, there is also approximately a $22,000 difference in the beginning penalty. So the appellant will suggest the record reflects the correct calculation of the beginning penalty as being $65,800 based on the retention of trees number 1 and number 5.
Excuse me, Your Honor, are these still opening remarks, or?
Yes, Your Honor.
Okay. Okay. Just wanted to make sure if we.
Yes.
Okay.
And finally, Your Honor, the appellant suggests the record reflects just and due cause for mitigation from the $66,000 figure we've just discussed, based on the following. First, the appellant recognizes that there's a fine to be imposed of either $100 or $200 at its minimum under the provisions of the code. $100 if the wrongful removal of the trees is viewed as one wrongful act. $200 if viewed as the improper removal of 2 trees is fined at $100 per tree. Secondly, the evidence will reflect, in addition to the fine, and the appellant will be seeking the minimal fine to be imposed. In addition to the fine, the appellant has proposed a protection and replacement plan as follows. First, the original plan proposed to replace the 5 trees we removed with 5 trees, as indicated earlier, to achieve a score as required under the code of 4.4 tree units. That's not a mitigating factor, but I wanted to make it clear for the sake of the record, the original plan is being proposed, and it does achieve the 4.4 tree unit score. In addition to the original plan, the record will reflect that the appellant is proposing to supplement with a tree plan by planting an additional 5 trees. Those additional 5 trees achieve a score under the code of at least 9.0 additional tree units. The point being, the evidence will reflect the appellant is proposing a total in mitigation of replacement plans that achieve a total of 13.4 tree units. This comes at a cost. The record will reflect the cost of planting these additional 5 trees achieving the 9.0 score. By the way, let me stop here and explain my comment about the 9.0. The code does not allow a score for trees in excess of certain limits. And so when I refer to 9.0 score at a minimum, what I want to point out is the record will reflect that the appellant is proposing to plant an additional new set of trees that exceeds the 9.0 score because of their size and type. I had stopped my remarks about cost. The evidence will reflect that these additional 5 trees proposed by the appellant cost approximately $7,000 to purchase and to plant. In addition to that, the evidence will reflect there's approximately $1,500 of site preparation that will be necessary before the trees can be purchased and planted. The cost of the supplemental replacement plan is approximately $8,500. That concludes my opening remarks. Oh, you didn't miss it. I just didn't direct any specific comment to it. We believe, I intend to address that issue as we present evidence establishing the appropriate tree density calculation at 4.4 rather than the 9.6 that the city is requesting. Yeah. Yeah, thank you. I'm sorry, Your Honor. I don't know if the city wants to have an opportunity to present their own opening statement, and then we... Oh, okay. Yeah, thank you. Your Honor, first, I guess before we start the questions and the answers, I would move that our exhibits are, as submitted, subject to the reservation about exhibits A12 through A14, that exhibits 1 through 11 be admitted as presented, unless there's objection. Okay? So, thank you. So, Your Honor, just so you understand, I wouldn't intend, if those exhibits are admitted, I don't intend to waste a lot of time repeating the information set forth in those exhibits. Okay. Mr. Metcalf, would you please spell your full name for the sake of the record?
Aaron Metcalf, Aaronmetcalf. And the company name is Bellmark LLC, not Bellmark Homes. It's just Bellmark LLC.
Are you the owner of Bellmark LLC?
That's correct.
Did Bellmark LLC apply to improve parcel within the city limits of Kenmore?
That is correct.
You recall when you applied? When you apply?
I don't recall exactly when I applied.
Do you recall approximately when you submitted an application?
It's on record, but it's I think it was October.
Do you remember which year?
Yeah, 2016.
Okay. And did you present with that application a tree protection and replanting plan?
Yes, I did.
Did you prepare that plan yourself?
No, I had a landscape architect do that, Crystal Lowe.
Okay.
I understand that there's a tree retention plan, but I didn't realize that you couldn't mitigate for those tree plantings, for those to cut down. I thought that you could mitigate for those for what you cut down from previous experiences in our projects that we've had.
How many previous experiences have you had with the city of Kenmore?
Literally in the last 2 years, we've built 9 homes in the city of Kenmore.
And as part of those projects, have you had prior occasion to request a permit for tree removal?
Yeah, on the project that we purchased at preliminary plat approval, there was a process of taking down trees, but on our other projects, there wasn't a process in which we would still have to mitigate for those trees that we cut down, but there was nothing that stated that we couldn't cut those down.
And when you say you had to mitigate, what do you mean by that?
We had to replace it on a ratio. I can't tell you exactly, but it was usually a 2-to-1, 3-to-1 type ratio.
And did you receive permits to replace the trees on some ratio in those prior projects?
I don't recall specifically on that.
Were any of those prior projects, did you receive any kind of notice of violation or stop work order that stopped development or improvement of the properties until a tree permit was issued?
I've never received a stop work order ever.
Okay.
In the city of Kenmore.
Did you personally or cause to be removed 5 trees from the subject property? Personally, or cause? Did you direct somebody?
Yes,
to
I
remove the
directed those people to remove those trees.
Okay. And do you recall when the trees were removed?
They were removed on the 17th of November, right before Thanksgiving timeframe.
By someone you hired to remove the trees?
Somebody that hired, yes, correct, a licensed contractor.
Do you recall how many trees were removed?
5 trees.
Okay. Did you leave any trees standing on the subject property?
No, there's a couple trees that are on that hug the property line, but because they were hugging the property line, we did not remove them.
Did you have a permit from the city of Kenmore before you removed the trees?
No.
Okay. What date were the trees removed?
The 17th of November,
Which year?
2016.
Okay. Before removing the trees, had you received any communication from the city of Kenmore directing you not to remove the trees?
No.
Did you ever receive any communication from the city of Kenmore telling you not to remove the trees?
No.
Did you receive a notice on November 21st, 2016, directing you not to remove the trees?
Yes.
Okay. I'm going to show you what has been submitted with appellant's materials as Exhibit 4. Mr. Metcalf, would you take a moment to look at Exhibit 4? Do you recognize this document?
Yes, this document summarizes the correction notice, or TILA summarized the correction notices from Zach and Samantha for the Planning and Engineering Department.
And what is the date of this communication?
November 21st.
Is this, do you recall receiving this letter?
I received it by email, and when I got the email, I couldn't print it because I always print for my files. For some reason, it doesn't. The file didn't print, So, but I did open the file, and at that time, I did realize, I read it, and it stated that I didn't have permission to do it. So I went up to the city, and got a copy of it, and that's and at that time, I corresponded with my landscape architect and said, I got an issue.
Do you recall when you received this letter?
November 21st.
The same date of the letter? The same date?
Yes,
appears
as
on the letter.
appears on the letter.
Okay.
That's correct.
And when did you first receive a hard copy of this letter?
November 21st in the afternoon.
In the afternoon? Do you remember
Mhm.
what time in the afternoon?
I don't know precisely, but Tila was there when she hand delivered it to me on the November 21st.
I'd like to turn your attention now to what's been admitted previously as Exhibit 3 to appellant's materials. Mr. Metcalf, would you take a moment to look at that document?
Yes,
Do you recognize that document?
yes.
What is it?
It's Samantha's comments that states that I can't cut down trees. Well, it's the planning department's correction notice on our permits that stated that we couldn't cut trees. However, it was part of the summary that was given to me on November 21st.
Okay. And so the date that appears at the top of this document is what?
November 16th.
Did you receive this document on November 16th?
No.
Did you receive this document any time prior to November 21st?
No.
You didn't receive it by email
No.
prior to the 21st?
No.
You didn't receive it by fax prior to the 21st?
No.
You didn't receive it by hand delivery prior to the 21st?
No.
Did you receive it prior to the 21st by any electronic means?
Not that I am aware of.
Next, I'd like to turn your attention to what's been admitted as appellant's exhibit number 5. Mr. Metcalf, would you take a moment to look at that document? You recognize this document?
Yes.
What is it?
It's a notice of violation, and the total that I received on December 5th, I think, December 5th, and this is the first time I knew I was in trouble, but when I saw $235,800, I definitely caught my attention, and I made sure that everybody knew that it caught my attention.
Excuse me. And again, for the sake of the record, what's the date of this document?
Date mailed is December 5th,
Which year?
2016.
I'm handing to you what's been previously marked and admitted as appellant's exhibit number 8. Would you take a moment to review that document?
Yes, I just want to make sure when I did get the first notice, that's when I found out the process. I went to the city and paid for the hearing that exact same day, which was stated. So sorry.
Would you take a minute to review exhibit
Yes.
number 8?
Got it.
Do you recognize this document?
Yes.
Is this an amended review comment document issued by the city?
That's correct.
Do you understand that it amends the previous exhibit we were just looking at dated December 5th?
Yes.
And how do you have an understanding about how this document amended the prior exhibit?
Yes.
Did it amend
Correct.
From what figure to what figure?
$235,800 to $88,600.
Do you have an understanding of why the city issued this amendment?
Because I had an existing permit in process, so they knew that I had the ability to cut down some trees.
So you had the ability to cut down some trees, but not all trees?
That was their opinion.
I think you previously testified that you submitted an application for tree protection and tree replacement in October of 2016. Is that correct?
Yes.
Do you recall whether you proposed a tree removal and replacement plan along with that application?
Yes, my plan showed that I was, with my landscape architect, stated that I was going to take down all the trees.
And do you recall focusing on the replacement part of that plan? How many trees you were planning to plant?
I'd have to review I'd let it speak for itself, whatever we submitted.
Do you recall whether the trees to be replanted complied with the minimum tree density standards under the code, the Kenmore Code?
As an owner of the company, and we bring in our professional consultants to make that determination, and that at that time that's what my consultant decided, because I wanted to cut down all the trees, so that's what she proposed.
You had previously testified that you first received notice that the city did not want you to remove all or some of the trees on November the 21st, 2016. Is that correct?
That's correct.
Did you remove the trees in direct contradiction from any communication from the city not to remove the trees?
No.
So, stated differently,
Sorry.
you removed the trees before you had any notice from the city whatsoever that the trees should not be removed.
That's correct.
Had you received notice from the city prior to removing the trees, not to remove the trees? Would you have removed the trees?
I would not have.
Why not?
I have a long relationship. I mean, I wouldn't say long, but we do business here. We want to continue to do business here. We've been successful at selling homes in this area. I have a great working relationship with this city, and you can see by our other projects in this city, I think we've improved the project or the lots or the land where we have developed, and has made it a better place to be.
Are you here today to propose a correction or mitigation plan?
My goal with the proposal that I put together is to make sure that the mistake that I made of taking down those trees, that the mistake is taken care of. The mitigation goes to the location that I made that mistake, which is the lot that we're building on. So that's why I proposed to put the larger trees. And I got a quote from Big Trees, which is a known entity in this area that grows larger trees, to put it. So we were trying to create a mitigation that is linked to the lot that was affected by what I did wrong.
And so would your correction plan include a monetary fine?
I would hope not, but how I understand it, that there will have to be some sort of a monetary fine established with it. And as a developer that develops bigger projects and so forth, I also understand that there's a potential for a precedence being set. And I would also state that because I went and did the larger trees, not the smaller trees that could be proposed, using my experience as a developer to propose the amount of trees that I did for only above a 6,000 square foot lot is definitely a sizable fine, especially if you had 15, 20 lots.
Mr. Metcalf, are you proposing that the fine portion of the penalty to be imposed be either $100 or $200 per occurrence?
Yes, that's what I'm proposing.
Are you also proposing the replanting of an additional 5 trees over and above the original replanting plan you submitted in support of your permit?
5 additional large trees.
Do you have any understanding about the tree unit score those additional 5 trees provide in mitigation?
I wasn't until you did the calculation.
Do you know what that calculation is?
I think you noted it was 13.6, or I'm not positive on that number.
Okay. Do you know how much it's going to cost you to plant these additional 5 trees?
Yeah, the quote that we got from Big Trees was about $7,000, and then it would cost us another additional grading to do that. So we figured it would cost us right around $8,500. That's before tax.
So the cost of the mitigation or correction plan that you're proposing is approximately $8,600 to $8,700 total?
That's correct. Plus that planting plan comes with a 1-year warranty on those trees.
Do you have to purchase that warranty?
No, it's just part of the transaction.
Is there any additional cost then for that warranty?
No, as long as they plant them and do it their way. They're not just going to drop off a set of trees. They will actually do the tree. We'll purchase the tree, and they will do the installation of those trees.
Before we turn to a discussion of mitigating factors, I want to return back to the correct tree density calculation. Do you have any understanding for a lot of Lot 1's area what the appropriate tree unit calculation should be under the city code?
I think it's 4.4 is what the calculation is.
Okay. Do you have any understanding of what standard the city is imposing?
9.6, I think.
Do you agree that the 9.6 tree unit standard is appropriate?
What we understand that it's not exactly what the code reads, so it's over and above the amount. And also, we were not the developer that short platted this project. We are only the owner of Lot 1 of the Vanderlanden short plat. We are not the owner of the existing house, and that actually was sold at the same time we bought the lot. So we have no ownership whatsoever in that other lot.
So Bellmark was not the party who submitted the original short plat application to create Lot 1.
That's correct.
You purchased Lot 1 from the owner who submitted for approval and achieved final approval of the short plat that created Lot 1.
That is correct. We are truly just bought a finished lot is all we did.
Mr. Metcalf, I want to turn your attention now to what's previously been invented as Appellant's Exhibit Number 8. Page 6 of that exhibit is what I'd like to turn your attention to. Would you take a moment to review that document?
Yep.
You recognize that document?
Yes,
Have you seen it before?
I have.
Okay, what does it depict?
It depicts the five trees that we cut down.
How does it depict those trees?
Just numbers 1 through 5.
I see some green.
Oh, the
circular
green
shapes.
circular shapes numbered 1 through 5.
And each of those shapes is numbered 1 through 5?
That's correct.
Okay. Do you see on the exhibit where the name of the road to the south of your property?
Yeah, Northeast Arrowhead Drive?
Yes.
Okay.
Looking then to the north, there's a little legend there indicating that directly north of the label Northeast Arrowhead Drive is your parcel. Is that correct?
That's correct.
That's lot 1 that we've been discussing?
That's lot 1, 67 by 95.
Okay. Those are the dimensions?
That's correct.
Okay. And we started to discuss the trees represented by the green circles on this map, and that each of those is numbered 1 through 5.
That's
Is that correct?
That's correct.
Okay. Based on your review of this drawing or exhibit, which of the 5 trees, if required to keep 2 of the 5 trees, as asserted by the city, which of the 5 trees would you have sought to retain? Would you identify them by number, please?
If we would probably try to save 1 and 5 if we could. It's just that driveway location for 5 would be challenging. 1 and 2 we might be able to keep. Keep in mind also the trees are also affected by they also establish grade. So they're not only a challenge of where they're located, but they also establish grade. So if you keep a tree, you then can't grade around that area as well. So I just want to make sure that point was stated.
Does this exhibit also depict the then proposed footprint of the home you plan to build on the property?
Yes.
Is tree number 2 within or without the proposed footprint of that home?
It's within the footprint.
If this footprint were the approved footprint of the proposed improvement, the home to be constructed, would there be any way tree number 2 could remain?
No.
So if I understand your testimony correctly, your concern about leaving tree 5 has to do with ingress and egress to the home you were going to construct.
That's correct.
There doesn't seem to be any dispute that you would have sought to retain tree number 1 had you known the city's comments or had the benefit of the city's comments before the removal. Is that right?
That's correct.
But clarify for the record, what are you saying about tree number 2 and its placement based on this proposal? Would you seek to keep it or seek to have it removed?
I would probably seek to have it removed. And also, I think the challenge with taking out number 3 and 4, then an arborist would probably have to be involved to see if the removal of 3 and 4 would affect number 2, because they are very close together and could affect their root systems. We didn't bring out an arborist to verify that, but I think that would be an issue.
So based on this proposed exhibit, you are also seeking, or would also be seeking to remove trees number 3 and 4?
That's correct.
Based on the proposed footprint of the house you intended to build?
Yes.
Okay. And you're suggesting that the removal of tree number 3 may have an impact on the need to remove tree number 2 as well?
That's correct.
Given its proximity to tree number 2?
That's correct.
Would tree number 4 have any impact, in your opinion, on the need to remove tree number 2?
Probably not.
Okay. Do you have any understanding about the economic impact of removing each of these trees?
I would say I was very surprised by the amount of the notice of violation.
Which amount are you referring to?
253, I'm not, 235, 800. I think we were fairly surprised by that number.
Do you have any understanding or reaction to the amended amount, $88,600?
Because this is only one lot, I know everybody thinks home builders make a lot of money, but $88,600 for one lot is an extreme amount of money.
Do you have any opinion as to what the correct pre-mitigation penalty should be based on your retention or proposed retention of trees number 1 and number 5 reflected in Exhibit A?
I mean, my goal is to show that I made a mistake and I would like to mitigate for it on that lot. So to know exactly what the value is of what a penalty should be. I mean, we're requesting $100 per occurrence of what we took down, and then mitigate the rest of that. Mitigate while we're under construction for the extra 5 trees.
The city has suggested that a tree density standard of 9.6 tree units is the appropriate standard under which your application can be approved or denied. Do you have any understanding about how imposing a tree unit score of 9.6, what that translates into in terms of the number, the size, or the type of species of trees that would need to be planted on your lot?
I can't tell you specifically what it is, but I mean, the biggest challenge that you have with trees is that when you plant them, they look nice, but when they grow, it's just really hard to have a jungle around a house, and it's just very difficult. And what we'll find is a lot of cities have decided that these trees are important to them, but once people move into it, they find that they grow and they eventually get cut down, and it's just very, very difficult to create a functioning lot when you have all these trees, and so I don't know the specific number, but I know the challenges with the people that purchase the lots or the houses, excuse me.
Okay. Lastly, I want to turn to the issue of mitigating factors and what you believe to be appropriate mitigating factors for the city, the examiner to consider in the course of this hearing. Some of this will be redundant from your previous testimony, but let's create a list of mitigating factors for the sake of the record. First, did you apply for a permit to remove these trees?
That was my submittal, yes.
And did you apply for the permit in approximately October of 2016?
That's correct.
And did your permit application include a tree retention and replacement plan?
That's correct.
And did that plan meet the then existing city code requirement for tree density units?
That was our understanding.
And were the trees removed on or about November 17th, 2016? That's
Correct.
And was that more than 30 days after you had applied for the tree removal?
Yes.
Did you cut the trees after receiving knowledge from the city that you were not authorized to cut the trees?
No,
But you cut the trees without the benefit of having first received a permit.
that is correct.
Upon receiving the city's notice of, do you recall receiving the city's notice of violation?
Yes.
Do you recall when you received it?
January 5th.
Is it possible you received it approximately December 5th?
Oh, December 5th, excuse me. I'm looking at the response due date, sorry. December 5th.
Yeah. And when you received the notice of violation from the city, did you immediately communicate with the city on November the 5th?
Immediately.
And in your communication with the city, did you admit that you'd made a mistake?
Yes.
Did you apologize for that mistake?
Repeatedly.
Are you here today proposing that you would comply with a true and correct tree density requirement of 4.4?
Yes.
And does that plan require you to plant 5 trees?
Yeah.
Paul?
Yes.
Are you further proposing that you plant an additional 5 trees?
Large trees.
And do you understand that together the original plan plus the supplemental plan or correction plan achieves a tree density score of 13.4?
That is correct.
And that's in excess of the 4.4 tree density standard that's required?
Yes.
Would the cost of that supplemental planning plan be approximately $8,500, factoring in the cost of the planting and the preparation of the site?
Yes.
Are you here today to request that the city's proposed mitigation figure of $88,000 be reduced to $66,000? The starting point.
The starting point.
Yeah, the
Correct.
starting point for the consideration of mitigation.
Starting point, correct.
Okay.
But I am requesting them to allow us just to mitigate for it. And the
Yes.
$100 and $200 fine.
Yeah. So, the reduced starting point from which you're requesting mitigation down to approximately $66,000 is based on, is that based on your, conceptually, the retention of trees number 1 and 5 instead of the retention of trees number 1 and 2 listed on Exhibit 8?
Yes.
And you're requesting that the appropriate correction plan impose a fine of $100 to $200, and the supplemental plan of planting 5 additional trees, which will cost a total of about $8,600 to $8,700.
That's correct.
That's what you're proposing here today?
That's what I'm proposing.
Okay, thank you.
I received all of those, so it was TILA summarized it and then all the attachments were attached. Yes. Yeah. How I read it, how I read it is that the city doesn't allow for zero, or for zero. So that was in the letter. So it wasn't specific, I agree, but it was inferred, I guess. Yeah, that's how I read it. Yeah. No. Not in my estimation.
I just have a couple of questions, and then Sam's also going to want to respond to some of their concerns. First of all, I want to acknowledge that Aaron was very cooperative and responsive when he first contacted us and throughout the back and forth. Oh, okay. Okay, I'm sorry. Okay, so you've explained how experienced you are as a developer, and especially in Kenmore, which means you also said you'd be familiar with our codes. If you acknowledge that you cut these trees down without a permit, so was that based on your previous experience that you would be allowed to cut them down?
You are correct. That is, I should have waited for that for the permit to move forward. But due to the fact that it was a spot lot that's already been approved and we had it and it was in the system for as long as it had, I made a poor assumption that we would be getting our permits.
So also, as a developer, are you familiar that approved short plats have conditions, among other things, about trees
Yes.
that you would be responsible for?
Yes. But to answer that question, I made the poor assumption that I could, as my application that I submitted, that I could take down the trees and mitigate for those trees that I was planning on removing.
But the mitigation would have been agreed upon during the review process, correct?
That's correct.
Okay. You stated that you had 2 specific trees that you wanted to keep. You cut them all down. So I'm not sure how that explains that you wanted to keep 2 of them. Why wouldn't you just cut down the 3 you thought you'd be able to cut down and keep the 2 that you wanted to keep?
I think the reason why we talked about lots 1 and, or sorry, not lots, trees 1 and 5 is because you were using the when you did the secondary violation complaint to reduce it from 253 to 88, the city made an assumption that 1 and 2 would be kept. And what we're saying is that you can make that same assumption that 1 and 5 could be kept, and due to the fact the fine is based off of the size of the tree, that's the argument we're making. We're not making the argument that we could keep 1 and 5. I've already stated that I made a mistake by taking those trees down, but the comment that was made is that 1 and 5 are smaller trees, which then would potentially reduce the fine. So to say that we were going to keep 1 and 2 has a higher fine value.
Okay, I guess no matter which trees, whether it was 1 and 2 or 1 and 5, you still didn't keep 2. So are you saying that you thought that you wouldn't have been required to keep any?
That's what my proposal stated when I made the application, that I was taking down all the trees.
Sam?
So is this the time, Mr. Examiner, to respond to the summary of the position? Not yet, still cross-examining. So just questions based on what they... Okay. Did you?
Okay, You stated that you think the fines for the trees should be $100 per tree. Can I ask what you're basing that on, since obviously replacement trees are going to cost a lot more than that?
We're basing that argument that we know we're going to have to probably pay a fine, but what we're saying is we're paying a fine and bringing in the big trees. So you would take the fine that we said of $100 or $200, depending on how you look at it, per occasion or per tree, and then you adding the mitigation, the additional mitigation of the big trees, the 5 big trees, which be a total penalty. What we're saying is a total penalty of a value of $8,600. So I'm not saying that we're just asking just for a small fine. We're saying that instead of a fine, that we would actually mitigate for the cutting down of the trees, meaning planting more trees and bigger trees.
Okay, thanks.
Sorry. Yes, the whole application it's truly a finished lot. So we just submitted a building permit, which is, this whole thing is around a building permit process. Technically, the way that and Samantha might be able to answer this more better than I do, but the bottom line is a short plat was approved. And at that point, a lot was created, lot 1. So the seller could sell that lot 1 to me, so which he did. And then the ability to, and then the next thing to do is submit a building permit. And that's what we did. I mean, Double Eagle was, we did some investment work on a project called West Creek in 2009, which was a finished lot project, which was also completely cleared, and we mitigated all the trees that were on that particular project. We did a 6-lot plat called Double Eagle that we bought at preliminary plat approval, but put the infrastructure in and took down a lot of trees because of that. We did a BLA that's right next to it, which was 2 lots that we cut down trees. And then we also... I haven't, but for one lot of $236,000, it's a lot of money. I didn't even pay that much for the lot. The trees are worth more than the lot. Had no clue.
I think I just have one more. So going back to your prior experience on projects in Kenmore, have you previously cut down trees without permits?
Not that not part of the, no. I mean, we always had a permit that was there.
So this was the first time?
That I recall, yes. I mean, we've also had inspections through that process, so I'd say no, we have not.
At one point, or actually maybe more than one, but you had said that you got your projects mixed up. You thought you were working on a different project and got confused, and that's why the trees were removed?
Oh, no. I don't recall that statement.
Okay, I think that's it on our questions.
I don't have any further witnesses.
So just for the record, I'm Samantha Loyick. I'm the associate planner. And I can provide some information in response to the appellant's summary of their position, and then Debbie can take it after that. But I just wanted to provide information based on the code and my history on the project. So in response to number 1, where the appellant said that the city incorrectly calculated the number of tree units, they're saying it should be 4.4 instead of 9.6. In response to that, the tree management and protection plan, including the tree minimum density of 9.6, was a condition of the related short plat, which is the Van der Linden preliminary short plat, file number PSP 2014-056. Right, and the intent is just to respond to what they presented. So it was part of the preliminary short plat that I mentioned, approved in August of 2015. And ultimately, it was recorded and conditions recorded on the face of the final short plat, and that recorded in May of 2016. The tree density calculation was performed at the time of preliminary short plat application based on the property size provided by the applicant, which is based on a survey. And that at that time, the property was 1. So what's now lot 1 and 2, prior to final approval, it was 1, and we calculated the tree density based on that. The survey noted that the property size was 13,775 square feet, or 0.32 acres. The calculation for that is 0.32 times 30 equals 9.6. At the time of preliminary short plat, this information was rolled into the city's conditions of approval, and it made it to the final short plat map as a condition of lot 2 to fulfill at building permit, or sorry, lot 1 to fulfill at building permit. And that is in the appellant's number 8 in my letter dated December 15th. That's the first thing. I took a partial screenshot of the condition that's on there. So the condition is already on the recorded final short plat. This follows the property. And it says that at the time of building permit for lot 1, the tree management plan shall provide a minimum of 9.6 tree units on site. So that is where the calculation came from. Limiting the tree management plan to lot 1 only and providing 4.4 tree units invalidates the condition noted on the final short plat map and conflicts with the intent of the condition. Moving on to number 2 of the appellant's summary of position, they said, let's see, the original tree protection plan Bellmark submitted meets or exceeds so they were saying that it meets the standards for the tree management code. What they submitted with the building permit is that they're saying it meets it. In response, the plan that they submitted proposes retaining 0 trees and providing all replacement trees. Kenmore Municipal Code, Section 18.57, which is the same section noted on the final plat map, notes that the city values the protection of existing trees. And the code references this in a number of places in that code section that is also, again, referenced on the final plat map. And the code describes how to meet your tree density by first adding up the value of existing trees before considering replacement trees. The code instructs the applicant to, quote, add up the tree unit values for all protected trees and divide by the total acreage of the net buildable area. And then it goes on to say how this is calculated, right? So that's one place that the code says, first look at existing trees, right? The code goes on to say that if the number of existing trees is not enough to meet the minimum tree density, then you consider replacement trees. And all of this is in KMC 18.57.060. So the idea that the plan they submitted with replacement trees only and removing a significant number of trees does not meet the tree standards presented in this chapter. So it doesn't meet the intent of the tree code. In fact, they had the opportunity to meet the tree retention, the 9.6, not the 4.4. The 9.6 could have been achieved by leaving two of the trees number 1 and 2. If those would have been left, trees number 1 and 2, as shown on the appellant's Exhibit 8, page 6, if trees number 1 and 2 could have been left, they would have exceeded the city's minimum requirement. But that didn't happen. So, and moving on to point 4 of the appellant's summary of position, they noted that the city incorrectly identified the trees that they would have requested to remove. So the city said that we believe they would have kept tree number 1 and 2. And they're saying today that they would have kept 1 and 5, but in fact, they really wouldn't have kept any. So the idea behind this is that it was not an error from the city in thinking that they would have kept 1 and 2. The idea is that 1 and 2 would have met the tree density requirement, and by shifting that building footprint, the same building, to the east, by shifting that, they could have retained trees 1 and 2. And they would have met their other setback requirements. So on the eastern property line, there's approximately 14 feet there. The minimum is 5. So they could have moved the whole house 9 feet east, the whole footprint, and they could have saved tree number 1 and 2, potentially others, but I would assume for sure they could keep tree number 1 and 2 and meet their minimum tree density requirement. I'd also like to know that it's not uncommon for developers to move the footprint of a building when there are conflicting improvements or trees. So it's very common that we see things shifted around it a little bit within the setbacks to achieve that tree retention. And that is the response to number 1, 2, and 4 of the appellant's summary of position, and I'll turn it over to Debbie Blessington.
Okay, I don't really have any more questions. So I guess we're done.
Well, I certainly can go through that now. Will I have an opportunity to cross the information that's presented in there? Okay, thank you. So I'm not exactly sure who to direct the question to, so I'll direct it, and then whoever wants to answer is okay with me. Did the city ever communicate its rejection of the proposed tree retention and replacement plan prior to November 17th?
Not that I know of, and
Thank you.
Okay.
Do you happen to know what the size of Lot 1 is, the lot that's subject to this proceeding?
No.
I think in earlier testimony you indicated it was approximately 6,300 square feet. Is that close to the size of the lot?
That sounds close.
And do I understand the city's testimony correctly that it's asserting that the 9.6 tree unit density standard is appropriate because that's the language that appears on the short plat?
That was the information from the short plat that ended up on the final plat map tied to that lot, so yes.
Is for any other parcel that's the size of 6,300 square feet, is a 9.6 tree density standard the appropriate standard for that size lot?
I would first check the plat map. I can't say what's appropriate for any other lot in Kenmore because they're all very different.
Let me refer you to exhibit, oh boy, I've got myself, exhibit A 12, I think it is. Do you have that document in front of you?
Yes.
It's a document that's entitled Comparison of Tree Density Requirements for Vanderlinden Short Plat Number Lot 1. Is that the document you're looking at?
Correct.
Would you take a moment to review the document, in particular the calculation performed at item number 1?
They're not.
Item number 1 is titled 4.4 Tree Units, parens, Original Tree Protection and Replacement Plan.
Oh, I see it.
Would you read the language underneath that title, 4.4 Tree Units?
The document says 6,362 square feet per tree protection and replacement plan submitted by Bellmark / 43,560 square feet in 1 acre times 30 tree units per acre of net buildable area. Then it gives a calculation equaling 4.4 tree units.
Would you read that calculation, please?
6,362 divided by 43,560 times 30 equals 0.146051423 times 30 equals 4.4 tree units.
I want to direct your attention to the elements of the calculation you've just read. Do you have any understanding of what the 6,362 foot figure refers to?
Can you tell me what that number is?
I'm asking, do you have any understanding of what that number is?
It looks up to be approximately the size of the lot.
And then the slash?
Slash.
And then do you have any understanding of what the next number is, 43,560?
It's an acre.
And do you understand that this language indicates that the numerator, 6,362, is being divided by the denominator, 43,560? Is that how you would read that?
That's how I would read that.
And then the formula says times 30. Do you have any understanding of why it would say times 30?
In the text above, it says 30 tree units per net buildable acre.
Do you recognize that as the standard in the Kirkland Municipal Code for the required?
In Kenmore?
Kenmore Municipal Code?
Yes.
And so I'm not suggesting you've performed the calculation. I'm just asking you to read it as it's presented. Would this appear to you to be a calculation of the required tree units for a lot the size of 6,362 square feet under the Kenmore Municipal Code?
For a lot that was not part of a previous subdivision with conditions, this seems reasonable.
So your answer is yes?
My answer is if it were not part of a subdivision with conditions, this would seem reasonable for a lot of that size.
Okay. If there are no conditions, your answer is this formula appears to be a calculation for a lot of 6,362 square feet.
Correct.
And so any parcel of this size, not subject to any other limiting condition, if this calculation is correct, would produce a tree unit calculation of approximately 4.4 tree units.
That's not how our code says it. Our code differentiates between subdivision, so a land use action requirement, and then individual tree removals for lots.
I'm sorry to interrupt. I'm not asking about that. I'm asking whether the calculation that appears in this exhibit A12 under paragraph 1, 6,362 divided by 43,560 times 30, does that appear to be the correct calculation? If the calculation is performed correctly as represented, does that appear to be, for a lot without any other limiting condition, the calculation that would be performed to determine the correct tree units required for the tree density of a lot this size?
No.
How is it incorrect?
For an individual lot, as in this example, this is not how we would calculate the number of tree units for that lot. Our code specifies for individual single-family lots, they have different standards than that of a subdivision.
What is the appropriate standard for an individual single-family
For
residence lot?
individual single-family tree removal, and it depends on the property characteristics, such as critical areas, there's a threshold in the code. And I don't have the code with me.
Sorry to interrupt. Such as, I didn't hear what you said. Such as what kind of a lot?
Such as, for limiting factors on a property. So I'm saying that for individual lots, the removal threshold, there's a threshold in our code, and it depends on the type of lot, because if there are other elements in a property, such as critical areas, then other code sections apply.
Okay, so how does this calculation differ from the proper calculation that should be made?
This calculation is not applicable because it is a calculation of one individual lot for tree retention. And the individual lot, if you were looking at it to build one house on one lot that had no related short plat information, we would look at the tree, thank you. We would look at the threshold information found in KMC section 15.25.070, which provides a threshold based on the lot size. So it says for a lot like this, which is for lots up to 10,000 square feet, which is this lot because it's less than that, 2 trees per year are allowed to be removed. That is how we look at an individual lot as shown on here. We do not do a calculation as shown.
What calculation will you perform to determine the required tree density to issue Bellmark's building permit?
In this instance, it is tied to a condition on a plat that was recorded. So we would hold this property as it says in the condition, recorded condition. That's what we would use. We would use 9.6 because it specifically ties it to the building permit for this lot.
Okay. So let me ask this question. Any other parcel, standalone parcel, that is approximately 6,300 square feet, without any kind of plat condition, what would the appropriate tree density calculation be for that kind of single-family residential lot, similarly situated without critical areas as the subject property is devoid of? What would that calculation be for the minimum tree density?
We don't have a calculation for that.
There's no calculation?
No.
There's no standard?
The standards that are used for subdivision are what we've gone over for the 30 tree units per net buildable area. That's a review that's done at the land use subdivision stage. And then, as for other lots that are existing lots that do not have anything tied to them, we look at the thresholds in Chapter 15, which talks about how many you can remove. So it doesn't say all the existing lots out there have this standard. It doesn't say that. It says the lots that are out there now can remove this many per year. It doesn't set a standard for existing lots. It sets a standard for developed lots, for new subdivisions.
And so my question, I understand your testimony, but I'm not sure that I'm asking my question in a way that gets to my point. So let me try to rephrase. Would you agree that the Bellmark property as presented for building permit application was approximately 6,300 square feet?
The property, yes.
The
property
area
size
of the property,
yeah.
the size of the property. Would you agree that at that time it had 5 trees on it?
Yes.
So if another parcel that was exactly situated in the same fashion, approximately 6,300 square feet with 5 trees, the same as the 5 trees that were on the Bellmark property before they were removed, would there be a tree unit requirement calculated as a condition of issuing a building permit?
It wouldn't be a tree density calculation. It would be a number of trees to compare with the allowed removal limits.
How would that comparison?
They would have, if this came in.
Please, so you understand. How would that comparison be made?
I don't understand the question.
I think you were suggesting that if a similarly situated parcel, not the Bellmark parcel, but a parcel not subject to any plat condition or other limiting factors such as critical area, of approximately 6,300 square feet with 5 trees on it, was submitted to for building permit application for a single-family residence, there would be no tree unit density calculation made. Is that correct?
Correct.
And then I was asking you, what calculation would be made if there were a request to remove some or all of the existing 5 trees along with the building permit?
On a property of this size, they would be allowed to remove 2 trees.
Because of the code provision you cited earlier, allowing 2 trees to be removed per year.
Correct.
Would they be allowed to remove 2 trees of any size or species?
Correct.
Would they be allowed under any circumstance to remove more than 2 trees?
Yes.
What are those circumstances?
If the tree is hazardous, then they could.
Any other condition? Any other?
Not that I can think of right now.
Okay. And so in review of such application, like the hypothetical we're suggesting, your testimony on behalf of the city is that there would be no tree unit calculation performed.
In the example given, not related to this project, yes.
Okay. And it's the city's testimony that the only reason, is it the city's testimony, the only reason this particular lot is being held to a 9.6 tree density standard. The reason is because that's the language that appears on the plat.
Correct.
Were you involved in the short plat approval process?
Yes.
Did you suggest or participate in the creation of that term, the standard of 9.6 tree units being imposed on the plat?
I did the planning review.
So you were involved.
I was involved with the tree review, yes.
Do you recall the circumstances under which the 9.6 tree density standard was created?
Yes.
What were those circumstances?
The property was subdividing from one large lot into 2 lots, and we took the net buildable area times 30.
What does that mean, times 30?
Times 30 tree units to determine the total, the 9.6 tree units that were required.
So for purposes, is it the city's testimony that for purposes of approving the short plat application, it does consider tree density, the tree density standard set forth in the Kenmore Municipal Code?
Yes.
But for purposes of a single-family development building permit application, it does not consider or calculate the tree density formula?
It considers the trees in a different way outside of the formula.
If the tree density formula were to be considered in response to the building permit application that Bellmark submitted, would you agree that the calculation performed under number 1 represents a true application of the municipal code tree density standard?
I don't think it applies to this project, but the calculation, can you restate your question?
Sure. If the tree unit density formula were going to be applied, I'm asking hypothetically, were going to be applied to the Bellmark property, given its size and its characterization, would you agree that the calculation shown under item number 1 represents the proper application of that tree density formula?
Yes.
And do you agree that, assuming the math is correct in this formula, that the product of that calculation is 4.4 tree units?
Yes.
Let me direct your attention to direct your attention to the second page of that exhibit. And you see that I've got additional calculations made there. Would you direct your attention to item number 3, please? It's entitled 9.6 tree units.
Okay.
Would you take a moment to review that calculation?
Okay.
Do you understand the point of the calculations reflected there to be to extrapolate the tree units imposed by imposing a 9.6 tree unit standard on a lot approximately 6,300 square feet?
I understand the intent, yes.
Okay. Direct your attention to item number 4. It's labeled 13.4 tree units. Take a moment and review that calculation, if you would, please.
Okay, I've reviewed it.
Similarly to the information presented under item number 3, do you understand the purpose of this calculation is to extrapolate the number of tree units per net buildable acre imposed by achieving a 13.4 tree unit density for a lot of approximately 6,300 square feet?
I understand the intent, yes.
Mr. Hearing Examiner, can I ask, we're not looking at random lots. We're looking at this lot, so I guess I'm not understanding the time we're spending on what may or may not be done on some other lot.
Is that made in the form of an objection to the information in this exhibit? Okay. The relevancy is simply running out the tree density calculation in the Kenmore Municipal Code under the terms and conditions presented by this case. The 4.4 we've asserted is the appropriate tree unit calculation for a lot of this size. That's under item number 1. Number 3, the 9.6 tree unit is obviously a calculation based on the city's assertion that that's the appropriate tree density standard for this parcel. And item number 4 at 13.4 should be recognized as the tree density standard achieved by the combination of the 4.4 plan submitted by Bellmark together with the 9.0 plus additional planting proposed as a correction plan and as part of the mitigation request. Yes, I am. So with that, Mr. Examiner, I would offer that Appellant's Exhibit A12 be admitted. I understood there was an objection on relevance to the exhibit. Or was it just to the testimony? Perhaps I misunderstood your earlier comments about demonstrating the relevance. If they're admitted without objection, I wouldn't need to demonstrate the relevance. I'm sorry. That wasn't what I was responding to. I'd understood, Mr. Examiner, that you had questions about the relevance of Exhibits A12 through A14, and were asking me to demonstrate that relevance. In part, I responded by saying I expected to be able to demonstrate the relevance in my closing argument. But now, as I'm cross-examining the city's comments, I'm introducing them. And do I understand now correctly that you're saying they've already been admitted, there's no need to lay foundation or do anything else to properly have them admitted as evidence? Okay, I apologize. I thank you for the reminder.
Mr. Examiner, can we ask about Exhibit A14?
Mr. Examiner, I'm sorry, I'm not finished with my cross.
Okay. Okay, we just had a question about that before we pass it.
Let me ask, has the city ever permitted the removal of all trees on a subject property, subject to a building permit application?
I don't know the answer to that.
To your knowledge, has the city ever permitted the removal of all trees on a subject property, which is subject to a building permit application?
I honestly, I don't know. I can't remember in inventory.
Asking based on your knowledge. You recall?
Not that I can remember.
Nothing further at this time.
Yeah, so what is A14? It looks like it's a memo, but I don't understand what the intent of it is as it relates to this case.
Yes.
Okay, thank you.
Sure. Thank you, everyone, for your time in attempting to clarify and help everybody understand how this situation has developed. Bellmark is here, as we've indicated during the testimony part and the opening part of this proceeding, that they removed the trees without the benefit of permit. There's never been any attempt to hide, to shirk, or to run from that fact. Unfortunately, the tree removal got out ahead of the actual permit issuance. The city is here to say the permit never would have been issued because the original plan for tree removal and tree protection was inadequate in their view. It was inadequate because it's their policy. They don't like tree removal, but the best we've heard from them today, they don't remember or are unaware of whether any other project has been approved on the basis of removing all trees from the subject property. I would submit to you that based on our research, Exhibit A14 refers to a prior project. It's an 8-lot residential project where all trees were removed and a replacement plan achieving 24 units was approved. The city position today that they never would have approved the original plan submitted by Bellmark to remove all 5 trees is contradicted by my reference to this prior project where all the trees, not some of them, but all of the trees were approved for removal and complete mitigation, achieving the then standard in place, which was not 30 units per buildable unit. It was just 20 tree units per buildable acre. And so the mitigation plan or the replacement plan that was approved in that project, and we're not talking about decades ago, we're talking about as recent as 2014. What we've been able to obtain about that project in review of public records indicates a complete removal of those trees and approval of replacement of trees achieving a 24-unit score under the requirement of a 20-unit requirement per buildable acre. That's the relevance of A14 we offer for your consideration. The point obviously is, as Bellmark, through its landscape architect, reviewed the plain requirements of the Kenmore Municipal Code, there was no indication that it was impermissible to propose a plan for removal of all the trees, assuming there was a replacement plan that met the clearly articulated tree density standards of the code. The city wants to argue now that there's no requirement for a lot such as Bellmark's to meet any particular tree density formula, because it's standing behind the fact that there's a provision on the short plat that imposes a tree density standard of 9.6. And the city presents for the first time today its explanation that the 9.6 standard is appropriate because it was negotiated. I'm having to speculate a little, so maybe this isn't correct. It was negotiated or otherwise imposed as a condition associated with the approval of the short plat. The city indicated, and we agree, that the pre-short plat area of the Vanderlind property is an area of approximately 13,775 square feet. Coincidentally, under the current tree density formula in the city code, the tree density score for a lot of that area is 9.6. Bellmark is not here today to ask to develop or improve both lots 1 and lots 2, or a total of 13,700 square feet. It's here and has applied to develop a lot of approximately 6,300 square feet. We submit under the KMC that if the city is concerned about achieving appropriate tree density standards under its own code, the appropriate measure of that standard would be 4.4 tree units for this size lot. It is illogical and befuddling that a 9.6 tree density standard would ever be imposed upon a single-family residential lot of just 6,300 square feet. The city isn't, I don't know what happened. I wasn't part, I didn't represent anybody during the short plat process. I don't know why the 9.6 standard is on the short plat. I'm here to submit it's the appropriate tree density standard under the then current and presently current formula for tree density calculation for the entire parcel 1 and parcel 2 area, not just for the 6,300 square foot lot 1 that is the subject of Bellmark's application. Again, not implying intent or ill motive. I think clearly if the city is able to produce, and they didn't produce during their presentation, a similarly situated parcel where they imposed more than twice the tree density calculation for a lot of this size, where they've done this in other situations, maybe they'd have some precedential ability or support to say the 9.6 standard applies only to lot 1, and that's what Bellmark needed to meet in its original replacement, retention and replacement plan. But there is no such evidence before the examiner. What's before the examiner is the appropriate calculation taken straight out of the municipal code itself, and the product of that calculation for a lot of this size is 4.4, not 9.6. The short plat language is unclear. As to which parcels the 9.6 standard applies to. Referring to Exhibit 8, page 1 of Exhibit 8, the city has quoted the condition that I'm discussing. It says, toward the bottom of the page, condition number 2 of the recorded short plat attached notes, colon, and I'm reading directly, a tree protection and planting plan in compliance with KMC. My copy, hard to read, I think it says 1857, shall be submitted for review and approval at the time of building permit review for Lot 1. The tree management plan shall provide a minimum of 9.6 tree units on site, parens, 30 tree units per net buildable acre. The problem with imposing that standard is the standard is outside the scope of the formula they're invoking by citing their own code. Exhibit A12. Page 2, item number 3, extrapolates the Exhibit A12, page 2, item number 3, accurately extrapolates for a lot of approximately 6,300 square feet, what the product of a 9.6 tree unit standard produces. It produces a 66 tree units per acre of net buildable area standard. The code only imposes 30 tree units per net buildable area. So the city's interpretation of the language on the plat and the imposition of the 9.6 tree unit standard on the Bellmark property is more than twice the standard set forth in their code. Incidentally, the original plan, together with the mitigation, the correction plan proposed by Bellmark, achieves a tree unit standard of 13.4. He does that voluntarily in mitigation of the actions that he's taken. That extrapolates to 92 tree units. He does that in mitigation to make up for the error, the mistake that he made. He is more than tripling in mitigation the tree density standard that would otherwise be imposed for any other lot of his size, approximately 6,300. And Bellmark respectfully submits, complying with 3 times the code requirement, tree unit standard is adequate and sufficient mitigation for the mistake that he's made. Bellmark's correction plan is reasonable under the circumstances. The city seems to assert that Bellmark removed the trees after it received notice not to do so, regardless of which standard applies. The evidence clearly indicates that's not the case, though the city's comments instructing Bellmark not to remove the trees were dated November 16th. I don't think there's any contradictory evidence before the examiner that suggests that the trees were not removed on November 17th, or that the comments not to remove the trees were delivered to Bellmark at any time prior to when the trees were removed. In fact, I asked on cross-examination, did the city produce the comments or any notice to Bellmark not to remove the trees prior to November 17th? And the city said no. Thirdly, I'm sorry, so to conclude that point, there's no question that Bellmark did not act to remove these trees. Though they admit they removed them without permit, they did not act to remove these trees after receiving any notice that they would not be allowed to remove these trees. On the 21st, we look at Aaron's behavior. He received an email the morning of the 21st of the city's comments restricting removal of the trees. He opened and reviewed the attachments but wasn't able to print them. So he immediately contacted the city and said, "Can I please come pick up a hard copy so I can review this?" And that's exactly what he did the very same day that he received the email. He also immediately informed the city that the trees had been cut down on the 17th. The notice of violation, the record reflects the initial notice of violation at Exhibit 5 to appellant's materials was issued on, or is dated December the 5th. Immediately upon receipt of that notice of violation, you can see by email reflected in Exhibit 6 that Aaron, Mr. Metcalf, responded by saying, "Hey, I cut the trees down on the 17th prior to receiving your notice on the 21st. I did it without permit, assuming the permit would be forthcoming. And I thought it would be forthcoming based on the protection and replacement plan I submitted with my original application." And he apologizes. That's what Exhibit 6 reflects. These aren't the acts of somebody who's trying to skirt or avoid the building requirements in the city of Canmore. He's testified that he's had prior projects, and he hopes to have continuing projects and good relationship with the city. The city has acknowledged that he's been cooperative throughout this process. Despite the testimony offered, Bellmark continues to assert that the appropriate starting point, the point from which mitigation factors should be considered, is the $66,000 figure, not the $88,000 figure. The city has suggested that trees number 1, and the difference, as the examiner may recall, is both parties acknowledge that tree number 1 could have been kept, but they disagree as to whether tree 2 or 5 would have been kept. It's somewhat irrelevant because Aaron knocked down all the trees, and he proposed a 5-tree replacement plan plus an additional 5-tree replacement plan that exceeds even the inappropriate standard the city is attempting to impose. However, the correct starting point, if we're going to speculate about what would have been done or could have been done, Bellmark submits, is the retention of trees 1 and 5. But as Mr. Metcalf testified, saving tree number 5 may not have been practical given the proposed building envelope because of ingress and egress issues. I've been to the site and I know that it's extremely tight off of the road. And I don't know how we could say, how the city could assert if he'd moved the building envelope, what did they say, 8 or 9 feet to the east, it would have been approved. We don't know that. We don't know, even if it would have been approved, whether such a design would have been acceptable to Bellmark and Mr. Metcalf in developing the property. So what could have or should have been done, we don't know. What we do know is that all trees were removed pursuant to the innocent but mistaken assumption the protection and replanting plan, which met the city's density requirements, would be approved. It's never okay. No matter how likely you think it is, a permit will be issued to proceed prior to the actual admission of the permit. Mr. Metcalf has admitted that, not only here today, but throughout these proceedings. And I think that's an important mitigation factor. His openness, his desire to, in the past, has demonstrated compliance with the code, and his desire to maintain in this project and in future a good working relationship and compliance with all of the city code requirements. He's freely admitted his mistake. Why would he do that if he wasn't interested and highly valued a position of compliance with the city's requirements? The correct starting point is $65,800, as we've mentioned. I've casually used the phrase approximately 66. The exact figure is $65,800. The difference, and the difference between the city's position and our position is the difference in size between tree number 2 and tree number 5. That difference is 11.4 inches based on the city's measurements and calculations. 11.4 times $2,000 per square inch results in a difference of $22,800. 88,600 minus 22,800 equals $65,800. So it's this figure that we respectfully assert is the appropriate beginning point for the mitigation. I said to you that I had a couple of objectives at the outset. One was to treat this as a mitigation hearing, concede the trees were removed without permit, correct the record. It is, we believe, an appropriate, fair, and reasonable read of the code and the circumstances that the correct record is the lot needs to meet the 4.4 tree density standard. The city does allow, as represented by the Glenbrook project, the complete removal of trees and full mitigation for that. The imposition of the 9.6 tree density standard far exceeds any reasonable interpretation of the municipal code tree density requirement. Bellmark is proposing, nevertheless, in its original plan plus its supplemental replanting plan, a plan which achieves 13.4 tree units, which is triple, effectively triple the requirement, more than triple the requirement under the code. Together with the openness, cooperation, desire to achieve or restore, achieve, and maintain an ongoing compliant good relationship with the city should all be considered. A few final points. Should all be considered, I should say, let me finish that thought, should all be considered as mitigation points off of the correct mitigation starting point of $65,800 based on the evidence that we've submitted. Now a few final points. The fine to be imposed, there was some question earlier about the fine to be imposed. And Bellmark is asserting it should be either $100 or $200. There is a little bit of nuance here that I want to explain. If the removal of the trees on the 17th is considered to be one wrongful occurrence, the minimum fine under the KMC is $100. city has amended their own notice of violation acknowledging they would have approved the removal of 3 trees, but would have required the retention of 2 trees. We don't agree, but for the sake of argument, if that's the standard that's going to be imposed, wrongfully removing 2 trees is the issue, not wrongfully removing 5 trees, except that they were all removed without benefit of permit. My point is, the removal of 2 trees under the minimum fine expressed in the code, I believe it's at KMC 1.20.200. The minimum fine that can be imposed as a result of the wrongful removal of 2 trees would be $100 per occurrence. If each tree were considered to be an occurrence, that's how we calculate the $200. That's not all, though, that Bellmark is here today to suggest is appropriate mitigation or correction. As I've said over and over again, it proposes a plan that achieves at least an additional tree unit score of 9.0. In fact, the trees, those additional 5 trees that it proposes, are of a species and size that go off the city's charts in terms of the tree density standard that should result. The effect, however, is the important point. As a result of removing 5 trees before, the city would have authorized the removal of 3 of them by its own admission. Bellmark is proposing to comply with a net tree density score of 13.4, more than 3 times than the code would require under its existing tree density ordinances. Bellmark didn't remove these trees for any economic benefit. There's no view enhancement. There's no screening, enhancement or destruction against an adjacent property that somehow would improve the value of Bellmark's property. That's conceded. I don't think there's any evidence to the contrary. Bellmark proposed a plan to replace the 5 trees removed with 5 trees, achieving the 4.4 density requirement. It also proposes an additional 5 trees. I don't understand how it could be reasonable to consider removing of the original 5 trees to be a benefit when the net proposal is to replace those 5 with 10 trees. The real point is Bellmark didn't act for selfish reasons or for gain. It made a mistake. On the wrongful assumption, the city would approve the original protection and replacement plan. The last point. Bellmark's not getting off by paying its proposed $200 fine. That's not what Bellmark is here to do. Bellmark is going to expend substantially more funds than $200 if that is the amount that's imposed as a fine. Bellmark will also pay an additional $8,500 to achieve this plan submitted to plant an additional 5 trees. This mistake will cost Bellmark at least, and we haven't even discussed the delay associated with the ongoing costs associated with construction financing and other components associated with delay, which there's no allegation that that's the fault of the city. I want to be clear about that. But there have been additional costs to Bellmark in having to go through this process, over and above the $8,600 to $8,700 appropriate level of mitigation Bellmark respectfully submits would be appropriate under these circumstances. Thank you.
I have a couple of comments right now. This is part of my closing. Can I do that? Okay. First of all, in A14, the memo states that all the trees were allowed to be removed, but it doesn't actually prove that. There's no documentation that all the trees were removed, at least not that's submitted here. Even so, that's an old code, and they were held to a previous code, not the current code. And Mr. Cruz referenced staff not knowing if there had been any previous projects where all the trees had been removed. Again, this is an older project, and the current staff can't really be expected to know the details of all previous projects in the city of Kenmore. Basically, well, those are my only questions. No, he said it's not time for my closing. No, I said the time for closing. Oh, it is now? Oh. This is time for closing. Oh, I'm sorry. Okay. No. Just, all of these issues and questions about tree density and code issues would have all been resolved through the review process. That's what the review process is for. But unfortunately, action was taken before the review process was completed. So Mr. Cruz was right in stating that we don't know what would have happened and what would have been approved because Mr. Metcalf didn't wait for the approval process to be completed.
Briefly, two points, Mr. Examiner. First, the city offers no evidence. Apparently, they say they don't know, but they offer no precedence for applying the 9.6 standard as they have. They offer no precedence to say that they never allow the complete removal of all trees on a property. We've recited a project where they did. They raise questions. They say it doesn't prove anything. The question I would have for the city is, do they or do they not admit that they have allowed complete tree removal as a part of any prior project submitted for permit review or application? And the reason it's an important question is because they're here today saying, as part of the calculation of the starting point for mitigation, that they would have allowed 3 of the trees. They don't dispute that. 3 of the 5 trees could have been removed. The other 2 couldn't. And I'm suggesting, through the evidence we've offered, they have allowed complete tree removal. They haven't denied it. They just said we can't remember, and we can't be expected to remember. Well, with all deference, I can understand that, but this is a proceeding where the city is applying its own code, and they're asserting complete tree removal was absolutely never justified, never reasonable, should never have been part of any plan that was proposed because it's not appropriate under the code. There isn't a code provision that says complete removal is improper. There isn't such a code provision. There are statements in their review comments saying we don't allow that, but there's no citation to a code provision, I would refer you to, for example, Exhibit 3, page 2. They say, indiscriminate removal or destruction of trees conflicts with city values. Not a particular KMC provision, with city values. They don't want it. I'm asking, what's the legal basis for that? They go on to say, removal of all trees on site conflict with city values and is not allowed. It doesn't conflict with the Kirkland Municipal Code. It conflicts with the city values. The reason we reduce these policies to code provisions is so the public can understand and have notice what the terms and conditions of compliance are. Well, I would submit a phrase such and a standard such as city values is so nebulous and subjective as to be applied indiscriminately. There's no standard here to not remove all trees as Bellmark had applied to do. If Bellmark had known by code it could not apply to remove all trees, I submit that the evidence presented to you today about Bellmark's approach to things supports the conclusion they would not have submitted a plan to remove all trees and to replace the same number of trees they removed as they did. If City Council or other appropriate legislative body wants to give proper notice under due process that removal of all trees indiscriminately or otherwise is not allowed with any tree as part of any tree protection and replacement plan, it ought to codify that value. That's why we have ordinances and statutes. The city cites no binding legal authority in support of whatever its values may be, in this comment or in any other document on the record. It is. Thank you. Thank you, Your Honor.